Well, welcome to the Aging Boomers. I'm your host, Frank Sampson. As most of you know, and on this show, we discuss some very important issues that affect boomers, their parents, and of course, what we know as an aging population. And I'm very excited for our first guest, but before I our guest, we only have one today. But before I introduce him, I like to let everybody know that today's show is sponsored by Senior Care Authority, a professional senior placement and elder care management organization that has a national network of advisors to help in determining the right path for senior living and receiving proper care. So whether it's in-home care, assisted living, residential or memory care, get the necessary advice from a senior care advisor in your area by calling Senior Care Authority at 888-809-1231, or you could go directly to their website at www.seniorcareauthority.com. And we have with us, back with us actually, Philip Lindsley. Philip is a senior attorney and founder of San Diego Elder Law and a certified elder law attorney and certified legal specialist, estate planning, trust, and probate. Phil is widely recognized, a widely recognized elder and special needs law attorney. His practice is limited to Medi-Cal and public benefits planning, special needs planning, life care planning, asset protection, probate and trust administration, and conservatorships and their alternatives. Phil is a certified elder law attorney. This specialization is accredited by the American Bar Association and the State Bar of California. Phil is also a State Bar of California certified legal specialist in estate planning, trusts, and probate law, and an accredited Veterans Administration attorney. Phil, it's great to have you back on the Aging Boomers. Thanks for joining us.
Frank, thanks for having me.
Yeah, so we're going to be talking about a subject matter that's near and dear to my heart because, as you know, Phil, in my business, we work with families and helping them find assisted living, memory care, and quite often we get referrals from skilled nursing facilities. Quite often we'll get a call from a family member whose loved one is going to be discharged from a skilled nursing facility, and they may not be ready to go home yet, and we're looking at maybe assisted living for them. But usually when that happens, everybody's in a panic. And the reason they're in a panic, as you probably know, you deal with this all the time, is it's like the decision is made a day or two prior to discharge that particular senior or family member, and everybody's scrambling. Many times family just, they're not prepared for it. They don't feel maybe mom or dad are ready to be discharged yet. It just seems like that's the norm. That's not the exception. Why do you think that is?
Well, first off, in many of these scenarios where you're talking about people being discharged, the family welcomes the discharge. I certainly wouldn't want to be in a skilled nursing facility any longer than I needed to be.
Right.
But there are situations where, as you said, that it just doesn't seem quite ready yet. And there are other situations where, frankly, perhaps mom has not been able to take care of dad for a long time, and before he fell and broke his hip, and really the family can't visualize any level of care anymore as appropriate skilled nursing. The problem, Frank, is that the incentives for the family and facility may not always align. For the family, they want the best setting for the level of care that's appropriate, and for the facility, their businesses, they want as good a profit margin as they can get. And the fact of the matter is they can get a better profit margin treating people for the short term that Medicare and insurance will pay, and less so for longer term, when it's sometimes known as custodial patients. So they have an incentive to move people out as quickly as possible that may not always be identical to what is medically the best option. And that's where the conflict begins.
So
people have rights at that point that they're simply not aware of, both under federal and state law. But the problem is that the facilities usually are delivering the information in commandments rather than conversation. So they will say something, as you pointed out, that we're discharging your father Thursday at 10 a.m. Have the car ready. We'll help you load him in the back. And that doesn't sound like there's a whole lot of room for discussion of options and whether or not that's appropriate. And most people assume that's what they have to do, whether or not it seems prudent to them or not.
So what are some of the rights that families would have? Both from, I know that you practice
discharge
law.
From skilled nursing. First, you should note that most of the law in this area is federal, and I know you have a national broadcast, Frank. So
Right.
States may add to this. They can't do less, but they can add more. We have some extra laws out here in California, but most of what I'm talking about here is federal law and applies everywhere. Most discharges are considered voluntary, the vast majority of them. So when they say it's time to go at Thursday and you don't know you have options, that's considered a voluntary discharge. It may not have sounded like it to you, but it is. If you're willing, however, to say, well, no, I don't think he's ready, or well let's talk about that, a new process that people aren't aware of comes into play, and it's considered voluntary discharge. And there are only 6 reasons under federal law that they can discharge people who are willing to say, well, wait a minute here, I'm not so sure this is appropriate. One is if they can prove that it's necessary for their welfare and their needs can't be met by the facility. Another is discharge is appropriate because their health has improved to the point where they no longer need that level of care. Another is the safety of individuals in the facility would be endangered. The fourth is that the health of other people will be endangered. And 5 is that there's refusal after proper notice and legal process to pay. And the final one is the facility ceases to exist. Notably, Frank, what's not on that list is we don't have any custodial beds. This is something people often hear, or we are a short-term care facility only, etc. This is where that incentive for the facility to not have people who are going to be on Medicaid or Medi-Cal comes into play. But under the law, that's not a grounds for discharge. It's quite clear. Form of payment is irrelevant. You cannot discharge, and there's no such thing as not having a, quote, custodial bed. If you're in a bed, you've got a bed. Medicare isn't paying anymore. That's not a grounds for, it may be a correct statement. It's not a grounds for discharge. Conversion to Medicaid is not a grounds for discharge. Difficult, demanding, problem residents aren't grounds for discharge. Somebody who talks a lot or wanders around the facility or howls at night. These are challenges for them, but these people need to be somewhere, and that's not grounds for discharge, for example.
So, I guess I understand, trying to understand from a skilled nursing facility standpoint that Medicare, and I would say that this is probably, and correct me if I'm wrong, but I would think the main reason for discharge is Medicare is not going to pay anymore. Okay.
Well, again, that's not a lawful reason for discharge. It may be true, although that's a whole issue in and of itself. Facilities are often applying the wrong standard about whether or not Medicare pays or not, and not even bothering to bill Medicare. And that could be a whole different podcast. But I tell you, it is an issue that the family needs to address. Number one, they need to ask, is this true? Is Medicare no longer paying? Do we have any appeal rights with Medicare on that issue? If Medicare is no longer paying, then the family has the right to discuss whether or not dad needs to stay there private paying, or if the family is able to qualify for the assistance from the long-term Medicaid or Medi-Cal program. And that particular Medicaid program, or as we call it, California Medi-Cal, has some substantial middle-class benefits, and a lot of people will qualify for assistance under that program that are not aware of that fact. And if somebody wants to stay there and do an application for that program and thinks they may be eligible for assistance, that is not grounds for discharge. So again, Medicare isn't paying anymore may or may not be a correct statement, but it's not grounds for discharge. It's grounds for the family to discuss whether or not there's other program options out there other than Medicare.
So, and one of the options is they can keep mom or dad there, but they have to pay. Private
well, they would
pay?
have to. Yes, they would have to pay. Now, of course, again, making sure that the statement that Medicare is not paying anymore is a correct statement. There's been a lot of litigation on that, and there's some interesting changes to the regulations in the last few years, enhancing people's ability to stay. But that said, let's assume that in fact Medicare payment no longer is an option. Yes, they certainly have the right to stay if they're private paying, and they certainly should take a look and see if there is a possibility for assistance under the Medicaid program. Again, a lot of families have no idea about the benefits that can come there. And there are particularly strong benefits if there is a spouse, what we call spousal protection rules, that allow quite a bit of credits for assets and still qualifying for the program. So I would suggest anybody who finds themselves in that situation and they don't think discharge back home or to assisted living or board and care is appropriate, to take a close look from somebody who's knowledgeable about Medicaid in their area, whether or not there's any benefits to be had under the long-term care Medicaid program. They may be surprised.
Let me ask you this, and this could be another podcast as well, what I'm going to ask you. But I'm going to ask you anyway, and maybe you could summarize, and could be another subject matter in the future. But readmissions to hospitals is a huge issue now, all right? And actually where hospitals are getting penalized should someone who gets discharged from a hospital now, we're not necessarily talking skilled nursing, but from a hospital, and they have to go back within 30 days for particular reasons, that it actually could penalize the hospital financially. And that process, and it's really Medicare setting that up, and that, if I understand it correctly, that process going from hospital to skilled nursing, getting discharged, then going back to the hospital, okay, has an effect on that hospital. So is it kind of a domino effect if the skilled nursing facility maybe discharges someone sooner than they should be, or they're not ready and they don't have the right type of care, end up back in the hospital? Doesn't that affect the whole system?
Well, Frank, this is a great policy issue that's going on right now and being debated right now. You're absolutely right. Medicare has changed some of their financial rules in the last year or so to penalize hospitals who, again, send people home and have a higher than normal or desired readmission rate. The thought being, if they did adequate discharge planning, adequate treatment prior to discharge, and then adequate discharge planning to assure that the supports for needed continuing care were in place, there wouldn't be so many hospital readmissions. There's a lot of logical appeal to that. There are, as with everything, there's a lot of subtleties in how that plays out across demographics and the like. But yes, right now that is something that's being wrestled with. And the efforts and the discussions going on in the healthcare community are, in fact, consistent with what the law currently provides is enhanced discussions about alternatives outside of the hospital and community supports for continuing care, what we often refer to as discharge planning. When people go from the hospital to skilled nursing on a related issue, sometimes when skilled nursing facilities realize that they don't have one of those grounds to discharge, and yet they have reason not to want a particular resident, perhaps they're problematic but not to the level of danger to others allowing discharge, they will pretextually sometimes send people back to the hospital and try to get rid of the resident that way. That is understood by the system, and so there are rights about what we call bed holds. Under federal law, somebody is allowed to have a bed hold for 7 days. They can pay for that at an administrative rate, and if they're on Medicaid, Medicaid will pay for that. And to prevent the incentive of facilities shuffling these people back and forth like a hot potato, the law provides that even if somebody stays in the hospital longer than their 7-day bed hold, that they have the right to return to that facility that they came from at the first available bed. And the hospital needs to hold them at the administrative day rate. People don't understand that.
Yeah, that's
but you and again, much of the system at skilled nursing and hospitals works because people don't really know what their rights are, and they just assume what they're being told are their only options. So, but people need to be aware of the bed hold rights if they want to return to that facility, and that they have the absolute right to go back to that facility. And that removes the incentive for the hot potato game.
Yeah. And as I say, they're, for profit. They want to, get them in, get them out, but that could have a huge negative effect on so many people and the hospitals, etc. So as it relates to, from a planning standpoint, because to me, the planning is so crucial, all right? And even though every person, every patient is different, there's no two that are exactly alike. That we know. However, the skilled nursing facilities deal with this a lot, and I would think from a planning standpoint, they would have an idea, even maybe at the time of admissions or shortly after, that to communicate with the family what could be happening. Because I have dealt with families myself who are just like, wow, we didn't even know they're going to be discharged. Wouldn't you think that do the nursing facilities, are they under some sort of I don't know if it's a regulation, but just from a planning standpoint to communicate well with the family? And some do and some don't.
Absolutely, and yet under the law, all are supposed to. Federal law, again, this is a matter of federal law, it's absolutely clear, and this is whether or not we're talking discharge from hospitals or skilled nursing facilities. You have people have a right to a written notification about discharge. Theoretically, the grounds for the discharge are supposed to be adequately documented in the chart. The law requires that there be an exploration by the discharge planners as to the alternatives in the community. The law mandates that the family be involved with this discussion. If there is a family and that wants to be involved, that there's got to be sufficient orientation and preparation, that the facility must provide orientation and a post-discharge plan of care, again, one developed in consultation with the family. And as you said, Frank, this is it sounds really nice, but it is, and sometimes is done. But I think more often than not, it's simply not. The grounds for discharge is, well, we're done here. We think our job is finished. It's time to move on. But that's not what the law requires. And again, it comes down to with anybody who's got a chronic condition with advocacy. It takes really, for best results, somebody needs either themselves to be willing to be an advocate and ask questions, or a family member willing to step up and say, well, wait a minute here. I've got some questions, or how's that going to work? I often tell my clients that if every time they are told something at a facility that sounds like a commandment or a statement about what is going to be, if they get in the habit of their mind of inserting in front of that statement the sentence, we would like to talk to you about ... or what is your opinion about, that those people will have, just by doing that, you'll have a much better idea of what the law requires, because that is what the law requires. The law requires that discussion with you, a thoughtful discussion, and an actual written plan by them that makes sense. So if mom was not able to take care of dad before the recent events, and now they're simply talking about, we're done here, time to send dad home, and anybody would take a look at it to realize there's no way mom's going to be able to do what needs to be done now. She was barely able to do it before. You need to let them know, and you need to require and that they do this. And the way to do it is say, no, we are not discharging him home. No, you are not doing that. We require some thoughtful discharge planning here. We require that you look into this and we do something that's sensible. And here's what we, the family, think.
Right. Because, maybe the person, the skilled nursing facility is correct to say, hey, they've done all they can do, and you don't want to, like you said, the last thing you want to do is stay in a nursing home any longer than you have to. However, it may be that the doctor says, listen, we're going to, discharge mom, but she's going to need 24-hour care, or somebody with her all the time, to decrease the chance of a fall or whatever the case may be. And that's really what the family has the challenge with. They didn't know that. Well, wait, we work. I don't have anybody to come in, and how much is that going to be, and all those types of things. So I think that seems to me to be a big issue. Is that what you run across quite often?
Yes. I mean, on one hand, you have the clinical opinions, and then on the other hand, you have the practical considerations of the support network and the cost. One family may have a large number of active involved people, and with some community support and maybe a little extra for some paid caregivers, dad may be able to stay at home. Another family may not have the same resources, and there's just no financial way, given their income and assets, that they're going to be able to pay for 24/7 caregivers. And if that's the case, maybe a discharge is inappropriate. I mean, you can't discuss discharges in a vacuum. As you said earlier, each fact situation is different. It may make sense for one person to leave skilled nursing because they have options for lower levels of placement that make sense clinically and make sense financially. Whether it's at home or assisted living or memory care, it may make sense. If it is not an option, and for that family it does not make sense, either because of the level of care required and the family resources or the finances, then maybe discharge is not appropriate. Maybe the family member is exactly where they need to be, regardless of what the facility feels about their profit margin, should that person start getting assistance from Medicaid or Medi-Cal. to stay there.
Boy, time just flew here. So we only have a couple minutes left, and we're of course going to have you back.
I got
in the
a
future.
hint. You know what? I'm not sure what you were going to ask, Frank, but all of your questions have been geared towards people being helping advocate for their families, getting the best care and the best placement. So I've got a hint here.
Okay.
For you people, for your listeners, if you don't mind.
Not at all.
If you've got a parent in skilled nursing and things aren't going, and I've been urging people to get involved here and know what their rights are, and things aren't going ideal, don't start yelling at the nursing assistant.
Right.
That I know you're frustrated. I know you want to see the best care for your parent, but you're yelling at the wrong person, and yelling isn't going to get you what you want. More likely than not, I've seen people who got overly frustrated end up with restraining orders, where the best family advocate now is sidelined. What you need to do, certainly talk to those people calmly. What you need to do is go talk to the director of nursing or somebody higher up and say, I have these issues. What do you think about this? What are you going to do? That will be a much better conversation. And if you hear things in that conversation you like, such as, well, yes, I agree, we need to check your father's for incontinence issues more frequently, or we need to turn them more frequently. Then you go home and you write a letter to that person and say, I was so happy to speak to you today. I am memorializing that you say that you're going to do this, this, and this. Once you put something in writing and send it to the facility, you have elevated yourself as to a person that will hold them accountable. They have to put that letter in the file. Now there's something objective. Don't yell at the nursing assistant.
Right.
Talk to the people higher up and document. And don't be hesitant to find out what your appeal rates are in your county. You will, under federal and state law, have the right to file complaints and appeals, and that documentation can only help.
That's a great. So that was going to be my next question. What tips do you have to family members? So you were reading my mind, and that's a great suggestion. So, Phil, I want everybody to know, how to learn more about your law firm. You specialize in this and many other areas. So why don't you share with people your website or any contact information at all?
Sure. We can be located at www.sandiegoelderlaw.com.
Okay.
I urge people, if they're having problems in this issue, to find in their area. If you're in San Diego, I'd love to hear from you, or California. If you're not, National Elder Law Foundation, that's NELF.org, will list the certified elder law attorneys in your area. The National Academy of Elder Law Attorneys, NAELA.org, also will list elder law practitioners, and they will indicate who in your local practitioners are certified specialists. The elder law attorney is the one that is trained in your rights in the healthcare system and trained as to the available public benefits assistance programs, and can help the family at that moment where they're wondering, oh my gosh, what do we do now? How do we pay for this? How do we get that care?
Great. Phil Lindsley, San Diego Elder Law, thank you again for joining us. Just very, very informative. And again, there's so many subject matters to discuss, so we'll have you back again. And thanks for joining us, and I want to thank everybody out there for joining us as well. Please, share our podcasts with friends and family. Of course, many of you can download it on a free app on your iPhone or Android phone. You could get it on iTunes, Spreaker, iHeartRadio, or to our website at theagingboomers.com. Thanks so much. Be safe out there, and we'll talk to you all soon.